CalSTRS. We're on time to start.
Yes. For the State Controller, Ms. Paquin. Here. For the Superintendent of Public Instruction, Mr. Johnson.
Here.
Ms. Yamamoto.
Here.
Ms. Bradford.
Here.
Ms. Erden.
Here.
For the State Treasurer, Mr. Rufino.
Here.
Mr. Berzant, you have a quorum.
Thank you. Let me
Oh.
just make a few opening remarks.
I'm sorry, Mr. Berzant, or Chairperson Berzant.
Oh.
I need to also read a statement. Thank
That's
you.
true. Thank you.
The CalSTRS board meetings are live web streamed and video archived and available to the public on calstrs.com. Individuals who wish to address the board should dial into the public comment line at 833-986-0555 and wait for the 10-minute public comment period at the end of the agenda item the caller wishes to address. For comments not pertaining to a specific agenda item, there will be an opportunity for additional statements at the end of the open session. Each caller is allowed a maximum of 3 minutes to speak. However, if there is not enough time for each caller to have 3 minutes, the timing will be at the discretion of the chair. To protect the privacy of callers under the age of 18 who wish to address the board, only their first name and affiliated organization may be provided. Other personal identifying information, such as their last name, age, or school, may not be shared. Thank you, Chairperson.
Thank you. I just want to make an observation, having been on the board for 2.5 years and watching how we've governed ourselves in those 2.5 years. I have to commend this board and staff on the skill with which we've operated, especially under unique circumstances for the past 1.5 years, 2 years. And I think it's a testimony to the value-driven organization that we have here at CalSTRS and the willingness to collaborate with one another and to listen to points of view that sometimes we agree with and sometimes we don't. And I think this is one of the reasons that CalSTRS has been so successful in meeting its obligations to its members and being recognized as one of the premier public pension funds in the world. And I am proud to be able to be part of this board. And I'm especially proud to be able to be part of this governance committee. And I want to thank all of you today who are here for making my experience a special one for these last 2.5 years. And with that, I will move to item 1, which is the approval of the agenda. May I have a motion? If there is no opposition, the agenda as presented will be approved. No opposition? Okay. Approval of the minutes. Yes, Karen.
Thank you. On page 4 of the minutes, the adjournment was by Chairperson Hendricks.
Thank you.
That change will be made. Is there a motion to approve the minutes? Second by Gail Miller. No opposition. The minutes will be approved. Now, moving to the meat of the agenda, action item number 3. We have with us our able consultant, Amy McDuffie. Amy, would you please present?
Certainly, and thank you, Mr. Chair, members of the committee. It is truly a pleasure to be back in this room today together. And typically when we have conversations with you about the future of the organization, it's always a wise thing to have those conversations in person. And you may recall that in July, the board approved a work plan for the board governance committee. You all participated in that, but it did so at the time with the understanding that, especially in the environment that we're in and all the changes, Mr. Chair, as you noted, that have occurred over the last 18 months, it would be timely at the offsite to take another look at what are the lessons learned from the pandemic. And so the board did that at the offsite last month. And there were 2 items that were referred to the Board Governance Committee work plan. And so since the board offsite, I've worked with your general counsel and the committee leadership to refresh the work plan for the governance committee for the remainder of this fiscal year. And so the action that's before the committee this morning is to make sure that the way that we've refreshed the committee work plan comports with not only the direction that you heard from the board during those discussions, but also the expectations that you all have as committee members as you work together through the rest of this fiscal year. So that is the ask that we'll be making this morning. The draft work plan is attachment 1 to item 3. I'm not sure the exact page in your diligent book, and I apologize for that. But I thought what I could do is preview the topics that have been added. And again, we'll get your direction on the what, but I also thought that it would be helpful if I provided some context around the how. How are we going to address these items so that we can get your additional feedback today on what else we may want to include. So the what first, let's start with that. So the 2 items that came from the board offsite are big items, and it's appropriate to take a look at them now. The first is with the advent of virtual mode of communication and meeting format, how does the board want to incorporate a virtual setting into its normal rhythms of meetings going forward? Of course, within the boundaries and parameters of your applicable law. And so there is the concept, and this is on page 2 of your board governance committee item. How can the board take advantage of a hybrid meeting format in the future, leveraging the lessons that we've learned from the pandemic? So we're going to be taking a look at some specific topics, especially looking at your responsibilities matrix, the decisions that the board makes across the regular board, all of its committees. What topics lend themselves well to a virtual setting? One topic that came up was board education, for example. So that will be tucked within that evaluation that we'll be making. We'll also be looking at, can board education be shifted to off-cycle, for example, or provided to the board in some different format, maybe for self-study or self-consumption, for example, in lieu of holding board education during regular meetings. That doesn't mean that all of your board education will go away within the meetings, but what it means is that we're going to look at what could be some recommendations that we would make, knowing what we know now. And then, of course, we're going to be looking at balancing meeting frequency and length, including preferences for time in between meetings in the format under which your regular meetings operate. And again, I think having a cadence of 6 meetings a year plus a couple of offsites, that's kind of our starting point to look at the landscape of your responsibilities and see how those are housed within the number of meetings, and making sure that you have sufficient break time, you have time to recharge as you focus on all of the topics that are typically before you in a regular board agenda. So that's the scope that we fleshed out on topic number 1, the hybrid meeting format. The second topic is board materials, meeting materials. And this was an interesting one, I have to say. The board materials template that all board and committee materials are built to, the spec, if you will. I was talking with your general counsel, and we couldn't actually remember when it first came into existence. We think it might have been the early 2000s, maybe. And that's kind of the write-up that you get, for example, which specifies the information that's to be supplied to you as a board. And the question is, given everything that, again, we've all collectively experienced, what is it that the board needs to make decisions? What is decision useful information? And of course, encompassing the board's preferences for how you make decisions. So we're going to take a look at the template. We're going to, of course, look at the materials and how they're delivered. We all know that there's new ways of delivery. You get videos, for example, from your investment staff on certain topics. And so those are the types of things that we're going to be looking at. Again, as we all are in this environment now, how can we leverage meeting materials delivery to provide you with decision useful information, but also make things a bit more efficient to the extent that we can. And this is all, of course, under the broader umbrella of continued effectiveness and efficiency for this board. So those are the two items. You'll see that the cadence that we took is to have those appear on the work plan as information items. So part two of this is, what does that look like in terms of bringing you information as a committee? The endpoint that we were looking for, so by the end of this fiscal year in May, we were hoping to be able to provide some suggested recommendations for the committee to entertain. And it's not listed as an action item because we thought these are such big substantive topics that it might be best to have a first reading, get your input, and then go from there. So this could very well extend into the next fiscal year, which I think is appropriate. But backing up from that, how would we get you to that point? So again, also in your committee write-up, we would like to survey the full board to get some alignment on a sense of principles behind what's the high-level direction that we should be using to support this evaluation for you as we develop recommendations. We'd like to bring the survey results to the committee for your January meeting. And that would be an opportunity for you to see the prerogative of the board and talk about that collectively. From there, we talked with your general counsel about having a walk away there as a set of operative principles that we can then use to liaise with other committee chairs, with your staff, to understand what their ideas are based on that set of operative principles. That would then allow us to bring that information to you in a package, if you will, along with maybe some peer research. And that could be wide-ranging peer research, not necessarily other public pensions within the US, but internationally, maybe other sectors as well, because we know best practices can be found anywhere. So we want to make sure we can harvest those nuggets where appropriate. All of that information would then come back to you in the form of some options for you to talk through and consider on both of these topics at the May meeting. And then if you are comfortable at that time, perhaps we can talk about what do we do as next steps. But it seems like, again, that this is such a meaty topic, maybe we'd want to take action later on in the next fiscal year. So, Mr. Chair, that is the overview of what we see before us. Again, today is just setting the plate. It's not diving deep on this, but if the committee has questions about what the plate has on it, or how we are about to undertake that work, or a specific direction, we'd love to hear that. So back to you, Mr. Chair.
Thank you, Amy. I guess I have one question with regard to the virtual meeting. And if we could have maybe our general counsel explain to us where we are in terms of the law presently in effect and when that law may continue or expire.
Thank you. Well, right now, we're in the status of the law is really continuing the executive order, allowing public meetings to happen virtually. The real difference for the board and for committee members is under the old law, if there was a virtual meeting or if there was a meeting where a board member was at a different location than the physical location, wherever that board member was had to be open to the public, had to be available, had to be accessible under all the appropriate accessibility standards. Under the virtual meeting, that's not necessarily the case. The accessibility is through the virtual platform. So it doesn't actually have to be a physical location. That law, that change in law is going to sunset in January. So the ability for, if legislature doesn't act and if the change is not continued, that means you would whipsaw back into the prior law where any virtual appearance or distant appearance by a board member would have to be in a physical, accessible, and noticed location. So for example, if I was a board member and was to do it from my home, I would have to put my home address. I would have to make sure that my home was physically accessible to, under the ADA and other rules. So it does present a real barrier to the kind of efficiency that you have right now. And also, I think a barrier to the tremendous amount of transparency and convenience that you're getting for the public to participate. So we're hoping, and I know that our legislative folks will keep you briefed on that. We're hoping there'll be some movement in the legislature to continue the ability to have virtual meetings past January. If not, then we're going to have to drop back and punt and figure out how we're going to go forward. Whether you can use locations, doesn't have to be your home. You could do it from a member service center or some other location. I've seen other organizations use public libraries or local government offices. Hopefully we won't be in that situation. And again, I think hopefully you'll get a little bit more from our legislative briefing in the full board. So I'm working with the chair and vice chair, your consultant, to try to stay on top of this and figure out how adaptable we have to be. If things don't continue this way, we'll have to adjust.
Thank you, Brian. I'd just like to make one observation. One of the goals that I think this committee has had is to tee it up, which is to be transparent, be effective, and be efficient. And I think that the ability to meet virtually has enhanced all three of those goals. And I would hope that we'd be able to stay on track on that. So anyway, for further discussion, I'm sure. Lynn, did you have a question?
Yes, thank you. And this is for Ms. McDuffie. Thank you for setting out such a thoughtful process on how you plan to go about surveying board members and gathering information and helping the committee define the topics, because they are very weighty topics and have a lot of importance. So just wanted to say we appreciate how you are planning to go about this. Thank you.
Thank you.
On some of this. She's been an active participant in putting all of this together and has been a tremendous help, I think, to me. And I'd like to have some of your views.
Thank you, Mr. Chair, and I echo all of your thoughts, and very excited for the process that we begun and we're continuing our home. Just because of the importance of which we all balance of each of those factors and tee it up. And I'd add a fourth E of our excellence. And we really seek to serve all and to do that very well, as we've been lucky to do to date. So really would encourage everyone to continue to share original thought, balance all the factors, and we look forward to carrying the discussion forward. Thank you.
If I might, I make the observation that there's been some discussion at our offsite about the format, and would anybody, the format of presentations made, would anyone like to sort of summarize the views that may have been expressed at the offsite? Mr. Chair?
Let's see, it's been a while since I pushed these buttons. There we go. Thank you, Mr. Chairman. At the offsite, I think where there was clear consensus that on a forward-looking basis that our presentations to the board and our subcommittees, that the presenters be thoughtful about being efficient, and that there be more time for discussion and questions. And I think from the feedback I received yesterday from the investment committee, we commend the staff for meeting that goal and that expectation right away and executing on that. And I think the second, so we'll continue to monitor that, Bill. And then secondly, we'll be working with the staff, especially in the written write-ups, so that perhaps executive summaries of some of the larger items could be presented to the board and the committee members, as opposed to some of the volumes of information we get written up. We can be more efficient with the written materials. And then thirdly, would be working with the consultants more directly in terms of meeting the needs and expectations of each committee that they serve, in terms of helping us think through critical issues of risks and the appropriate questions. Thank you, Bro.
Thank you, Mr. Kiley. Next up is Joy Higa.
Thank you, Bill. And I'm not actually a member of the committee, so I couldn't remember the rules and whether it's okay for me to make a comment, but I
I would
will,
love to have your
since you've
comment.
given me the floor. I think, Bill, you summarized it really well when you talked about what we hope to gain with some of the items on the work plan. And I think the other thing that I would emphasize is, we know that we as a board and on all of our staff are also managing a lot of really important work and projects. And I think both having the opportunity to look at how we meet and how we streamline the materials, I think we hope will also have a positive impact on the burden on our staff, between meetings, doing write-ups, reports, et cetera. So, I think it'll be board efficiency and also system efficiency.
Great.
Thank you.
Any other comments, questions? I guess the next, anything do you want to add, Amy?
Just one thing, Mr. Chair, I wanted to underscore, I don't think I said it before, but the meeting materials template has served you well. And so even though it is, we couldn't actually identify a date that it came into circulation, that I don't take that that's a bad thing. This is a template that has served you well for many, many, many years. And that's why I think we want to take a thoughtful approach to any changes that you would make to it to reflect contemporary circumstances. So I did want to underscore that it's not a negative thing. It's not that there is a problem. It's that this is an enhancement that aligns with the needs of the board right now and in the future. Thank you.
Thank you. Anything else? Is there any public comment on this item?
There's no public comment on this item.
Okay, thank you. Moving on to the next agenda item.
Mr. Chair?
Yes.
If I may, we need to seek action from the committee to adopt or approve.
I'm sorry, yes.
The work plan.
The work plan that is attached
Thank
to
you.
the written materials is on diligent. Do we have a motion to approve the work plan? We have a motion and a second, and we'll have a vote.
Ms. Maitland? Yes. Mr. Johnson?
Yes.
Ms. Yamamoto?
Aye.
Ms. Bradford?
Yes.
Ms. Erden?
Yes.
Mr. Ruffino?
Yes.
Ms. Miller? Mr. Prezant, would you like to vote?
Aye,
The motion passes.
thank you. No public comment. We'll move to the next item. Revision of the Board Governance Manual Form 600H compliance.
Thank you, Wyatt. Jennifer comes up and joins us. I want to give a little background and introduce her to you. So thank you, Jennifer. So Jennifer Miskowitz is our Ethics and Accountability Counsel. She's been with us for a couple of months now. So as you can imagine, it's a learning cliff. There's a lot to learn. This is a position that you'll remember that Jill Lukens filled for a number of years, providing support on ethics issues and other conflict of interest issues. And Jill, of course, is now your Assistant General Counsel. So you'll be seeing a lot more of Jennifer. Her background is she's 15 years as a prosecutor in Placer County, including being a supervising deputy district attorney. So she has a lot of experience that is useful in this position, and we're really happy to have her. The other thing I wanted to tell you is the reason that we're here on this is because the Office of General Counsel retains oversight over the Form 700 and Form 600. Form 600 is the campaign contributions, because we're all well aware that pay to play has been a problem in other institutions, and we're very careful about reviewing all of the filings. As you all know, I personally review the Form 700s of all the board members and executives. Form 600 is very important to us. I also want to mention two people because you never see them. There are a lot of people who do this, who work on this, but I think it's important to mention Valerie Getz, who some of you have dealt with on the Form 700. And then our investment partners. And there's a whole, under April's organization, there's a whole effort to keep all of our contractors, all of our managers in compliance. And and all of our staff. And one of the people that leads that you never see is Sanjay Singh. And I remember having a conversation with him during the lockdown. Say, well, I'm concerned. I want to make sure that we get training out to all the new hires on these issues. And he said, well, I sit down, explain everything to them personally. So he actually takes the time to explain all the rules to them personally. And I think that's why every year we have 100% compliance. So one of the things that in working with them, we recognize that there's a little bit more that we could do to ensure compliance. And that's what Jennifer wants to present to you today.
Thank you, Brian.
Thank you for those words, Brian. As Brian indicated, my name is Jennifer Miskowitz, and I'm your new legal ethics and accountability attorney. I've been with CalSTRS for just shy of 3 months now, and I just wanted to share with you all that one of the things I've been doing to acquaint myself with some of the issues that the board faces and that CalSTRS faces is watching some of the archived board videos and committee videos. And of course, I've been watching live streams since I've been an employee. And I have to tell you, it is far more exciting to be here in person and certainly more exciting to be presenting in front of all of you. So thank you for this opportunity. Thank you, Brian, for this opportunity. The purpose for me coming before you today is to propose a modification to the board governance manual, specifically section 4, subsection G7. Now, for context, I understand that the committee members may already be familiar with that particular section and subsection, but for those that are watching or those maybe out in the audience who haven't quite memorized the board governance manual yet, I thought I would give some context to what this particular section entails. So section 4, subsection G, covers the CalSTRS third-party economic interest disclosure policy. Now, that policy requires disclosures of campaign contributions, charitable contributions, and gifts by those that we can conduct business with. We require disclosures to be done by way of submitting a Form 600, and that is really done at 4 key stages in the contract process. The first is at the initial application or proposal for business with CalSTRS. The second time we require it is when we are actually in contract with someone, or with a business. The third time we require it is when we are in contract and we require the form to be completed annually, and that needs to be done on or before April 1st. And finally, we also require submission of the form when there's been any sort of change to key personnel, and that really needs to be done within 5 days if there's been any sort of change. So I just wanted to lay kind of that groundwork in terms of the policy, the requirements of submitting the Form 600. Now, the current sanctions for non-compliance, quite frankly, are a bit thin, and that is why I am here before you today. There is really only one sanction for those that are non-compliant with Form 600 as it stands today. The language reads as follows, it's brief. Any violation of this policy may lead to disqualification from future business with CalSTRS for a period of 2 years following a determination by the board that a violation has occurred. Further, the general counsel is responsible for causing an investigation of any reported violation to be made and shall report any documented violation to the board for action. Now, the new proposed language still keeps the language that the general counsel is responsible for causing an investigation of any reported violation of the policy. However, the new suggested modified language does suggest 2 additional sanctions, and those read as follows. Any violation may lead to one or more of the following: immediate termination of any agreement or contract, 2, CalSTRS withholding future payments on any existing agreement or contract, and or 3, disqualification from future business with CalSTRS for a period of up to 2 years following a determination by the board that a violation has occurred. We're also proposing that these sanctions will be at CalSTRS' sole discretion and upon written notice from CalSTRS to the entity that we're doing business with. And lastly, we're also proposing that the general counsel shall provide an annual report of violations to the Audits and Risk Management Committee. So what will these modifications do? Well, the first is pretty obvious. We're proposing 2 new remedies, if you will, for those that are non-compliant with Form 600. And certainly I have to think that contract termination and non-payment on future services is going to be a wake-up call for those that are not compliant and will certainly get their attention. But these modifications also allow for sanctions that are more immediate and punitive than the remedies that are even really currently available to us for breach of contract. Just to give the committee an example, CalSTRS does have the ability to terminate a contract, but we have to do so with 30 days notice. These sanctions that we are proposing currently don't require that 30-day notice. We would be required to notify the entity that we are terminating the contract, but it does not require the 30 days. So really these new provisions, or excuse me, these new modifications allow for us to act quickly when there are issues, if issues arise. Third and finally, these modifications provide oversight by providing language that the General Counsel shall report to the Audits and Risk Management Committee. Which interestingly, I think is going to be another tool for to gain compliance, because I think it is probably fair to say that most that we do business with are not going to want their names or their company's names before the board in terms of non-compliance. Now, just a parting comment before I turn it over if there's any questions or comments. I don't want to suggest that there are major issues currently with compliance in terms of Form 600. I think that it is important for us to be forward thinking and really getting the tools that we need in the event that there are issues in the future. So much better to be proactive than reactive. And that's really what these modifications seek to do. So with that, if there's any questions or comments.
Thank you, Jennifer. Karen?
Oh, thank you, Mr. Chair. Thank you, Jennifer. Nice to meet you and welcome.
Thank you.
I have a couple of questions. The first one is on line, 6 of the proposed language where it says CalSTRS sole discretion. Is it, who are we talking about when we say CalSTRS? Is it the board? Is it
No.
who, how?
No, if there's an issue with the contract, it would be CalSTRS, whoever's managing that contract.
Okay.
That's who's going to have the discretion. It would be too time consuming if we were to have to come back to the board for something like that.
Can you give me an example of who that person with CalSTRS would be? Would it be like the divisions, or I guess I'm not hearing that.
I can help you with that a little bit, Jennifer, only because Jennifer hasn't really seen in action what happens. Every year there are some contractors we have to metaphorically pull teeth to get this done, to be in compliance. And, sometimes they just blow it off. And so the idea is to have some additional tools to get their attention. But it is a permissive, that's why it says sole discretion. It doesn't mean that we have to terminate their contract. Mm-hmm. So in our discussion with investments, let's say, for example, they have managers that they do business with, and there's a lot of, money at stake, and there's long relationships. So if they are not recommending that we pursue that avenue of termination, then that's something we would take their cue from. On the other hand, if they were to say, we want to invoke this section, then that would be something that would come to our office, the General Counsel's office. We would review it, we'd review the contract. And quite frankly, if it was significant enough, I would notify you. If it was significant enough, something that would make the papers, something that is could have a financial, I would notify you. The reason that we have put it in annually, which I think was a great suggestion to put it in the ARM committee, is because over the last dozen years or so that I've been here, we've only had one violation. What we really, the real reason we need the tool is because we spend a lot of time chasing people down, a lot of time trying to get their attention. And they recognize that it's in the contract, but we don't really have, it's just getting them to file the information is really difficult. And the staff I mentioned do this, on a regular basis. We get involved. Sometimes I'm calling, CEOs and other people, compliance people, to get them filed at the last minute. So in our discussions with our investment partners, because they really do a lot of this work, they said we need additional tools to get this done. So that's the purpose behind it. But it would not be, it's really an atom bomb, and so it would not be used unless, first of all, it was recommended by those that run the contract, and then second, it would have to go through some legal review, and then it would be presented to you in a report. which, I think if history will show us, we won't get there.
So you're saying that the second part is, so then these type of sanctions would be like best practices for other systems? Or is it unique to CalSTRS?
I'd say the CalSTRS enforcement of these sort of pay-to-play protections is very unique and has been for many years. So we had a placement agent policy before there was a placement agent scandal. We have really been proactive on these issues, and your reputation shows it, and so does the organization. Every year we get 100% compliance on Form 700s, and that may involve, I don't know, this is a great board, but that may involve me calling you up. If you're inside the building, I may show up at your desk. We will get the form. We will get it filed. And that's really what we want to continue to do, is have people recognize that this is really important stuff for a public agency where there's this much money involved. And it may seem like a hassle, but it's something that we need to do as public servants. So this is a necessary tool for us.
Thank you. Thank you, Mr. Chair.
Brian, you're sort of like the posse chasing Butch Cassidy and Sundance Kid, huh? Is that what you're saying? You go after them.
Sort of, but I hope they don't come out with guns blazing. But yeah.
Any other questions or comments? Amy?
Mr. Chair, if I may just add just 2 points in terms of the policy language. The first is, it seems like this is an event that doesn't happen very frequently, so that these are tools that you're adding to the toolkit, but they wouldn't be used very frequently. And I just had to wonder about the last sentence that talks about the general counsel providing annual report of violations to the Audits and Risk Management Committee. If there's a better way to align it, because it seems like if an event happened earlier in the year, but the audit committee didn't hear about it for a lengthy period of time after that, is that really the right approach? I don't know. It's just a question I had, maybe to remove the word annual, which suggests more of a routine occurrence versus something that would be significant and rare in terms of the circumstance there.
I think that's an awesome suggestion. That's why I love working with a board governance consultant.
Okay.
I think that's an awesome suggestion.
Okay.
Thank you.
Okay. So then it would read something like the general counsel shall report violations to the Audits and Risk Management Committee.
I think
That would be a simple suggestion that I would make as a amendment. And then the second question was, because this is always a behavioral change that you are trying to invoke, is just to talk a bit about the communications out to, in particular, existing vendors. Typically when you have a policy like this that people are subject to, you want to notify them in advance that a change has been made and we want to call your attention to it. That's part of generating the awareness that then contributes to their compliance with behavior that you'd like later on. And so I thought maybe it'd be helpful for the committee to hear about how you would plan to implement the new policy language if it were adopted.
So it's a good question. We have a series of communications, just like we have on the Form 700s, that really is, here's a filing season, here's what you have to do. We send out another notice at a particular time, it's 2 or 3 weeks later. And then I think we send out a third notice, and then we try to get compliance. So for this particular change, it would be in our notice letters that we would provide them with additional information about the new requirements, the new enforcement tools, and probably attach the actual policy to the letter, or include at least this operative paragraph. So that would be part of it.
Thank you.
Again, Amy, thank you for your input. Very helpful. With the modification proposed by Amy to the proposal, is there a motion to adopt? And a motion made by Gail Miller, second by Denise. Sorry. Katie?
Ms. Paquin? Aye. Mr. Johnson?
Aye.
Ms. Yamamoto?
Aye.
Ms. Bradford? Aye. Ms. Erden? Yes. Mr. Rufino?
Yes.
Ms. Miller? Aye. Mr. Prezant?
Aye.
The motion passes.
Is there any public comment on this item?
There are no public commenters in queue for this item.
The next agenda item is review of information requests. I don't think there have been any information requests, but none. Okay. And the final item on the agenda is opportunity for statements from the public. This is the opportunity for the public to make their statements. Is there anybody in the queue?
There is one caller in the queue.
Okay, and I believe that the time limit is how much on this item?
It'll be 3 minutes.
Okay, 3 minutes. Thank you.
Okay, we'll just give us a minute for the timer to come up. Okay, so our caller is Lisa. Lisa, go ahead.
Hi, good afternoon, Board Chair Kylie and board members. I'm Lisa Sherman Colt, Executive Director of Oakland School for the Arts. Oakland School for the Arts is a public charter school in the Oakland Unified School District that opened its doors in 2002 with a mission to offer immersive arts experience in a college preparatory setting. We presently serve over 800 students. I'm here today to ask for your help. Some years ago, due to a misunderstanding and a change in state eligibility laws, OSA did not pay the proper amount to CalSTRS and our employees. As a result of an audit of past and present employees, OSA learned that a shortfall correction of $1.2 million was owed, and this has been paid in full. OSA has implemented a stringent internal audit process to ensure that such oversights do not occur in the future. OSA is now required to reimburse CalSTRS an additional $1.2 million in interest and penalties. And this expense comes at a time when OSA can least afford unexpected costs. The COVID-19 pandemic has added immense financial challenges, accelerating long-standing structural budget issues associated with running the school. And due to decreased state and federal funding, lost monies from shows, and the decline of crucial billboard revenues needed to fund OSA's over $900,000 in annual rent, the school finds itself at a dire crossroads and facing a significant budget gap. Considering the school's dire financial footing, we are requesting CalSTRS forgiveness for the $1.2 million due in interest and penalties. I appreciate your consideration and I'm available to answer your questions. I sent a memo to the board yesterday that includes my email. Thank you.
Thank you for your comment. That is the last person in the queue for public comment.
Thank you very much. I believe I overlooked item number 6, which is the draft agenda for the next meeting. Any corrections or additions that any members want to make to that? Hearing none. Yes, Amy.
Governance work plan, that there will be some changes that will flow through as a result of that newly approved work plan.
I'm sorry.
So the 2 items that we talked about and the committee just approved on the work plan, review of the hybrid meeting format and the board meeting materials, that will be bringing some information to the committee at that point. That's not been reflected on the draft agenda that's before you because the committee had not yet had the opportunity to consider and approve the work plan. So I just wanted to point out that.
Yeah. Okay.
mismatch.
Thank you. All right. I think we stand adjourned. Thanks.
So if it's okay with everyone,